with construction happening next year sometime.
Cool. I drive through that way a lot, so I see
Yeah.
that rock cut. I knew it was on the list, it was just kind of
Yeah.
when we get to it, so
Yeah.
that's good to hear.
Any questions about Monroe? Any further on that? Okay, we'll go to Militia Drive. So Militia is one that has been an idea for about as long as Wildwood Drive has. We never did any kind of design or anything on that, never really pursued that seriously. It's just been an idea since the mid to late 2000s. There's 4 property owners impacted directly south of the Highway 50 interchange. And we've met with all 4, talked to them, and through the process, as we started kind of developing these city-county cooperative projects, determined that rather than hire an engineering consultant to do some preliminary design work, let's save that money and let the city do some alignments on paper, which is really what we need. We just need some alignments to talk to property owners to see where this road would best fit, and with the idea that this road will connect up to Liberty Road, allow more connectivity to the interchange and then over to the Ike Skelton and the Algoa industrial area, and also be compatible with a future extension to the south. There's always been the talk that, hey, 179 could come around, make a loop and hit this side of town at some point. That's really very far off in the future. There'd be so many river crossings on the Morrow that it's not real feasible to consider that in a realistic way. So let's not think of that as this connection. Let's think of a connection that could go to the south, maybe to Shamrock Road, or take it over to Route M, a little south or west of Taos. So that is kind of the idea here. Depending on which alignment you go with, it kind of looks like a little octopus drawing there. Interesting drawing. Either of these alignments could work, and it's really, I think it'll be a combination of let's talk to the property owners and see where they're at on things. There's been, I know 2 property owners for sure have looked at some development activities. One at one time was looking at possibly a truck stop, but that ended up going on the other side of the highway. But the property still remains as good, development opportunities at the interchange. And so we just need to, as we start developing this project and taking it to a more, hey, this is where it's gonna go, and let's look at some plans for future construction, we need to have all the property owners on board. And so with David's preliminary layouts, we can start talking to people. Our recommendation at this point is to hold a meeting with the 4 affected property owners in the 4 quadrants directly south of the interchange up to Liberty Road, and then get their take on things. And then once we have a little better idea, or maybe maybe a property owner is really ready to start some development, then we can make a decision on where this road would best be fit. So that's really the update at this time. No movement as far as any cost or expenses right now. We really need to get a better idea of where exactly we want this to go. Options to present to property owners. So the next step, maybe over the course of the next few months, have a meeting. Of course, invite commission and city council members in that area, and just keep the process going. And ultimately, this could develop into a project. So, any questions about Wildwood?
So you're planning on the next couple of months trying to get the meetings together, so if we can keep that moving. Because the biggest difference between this one and Wildwood is Wildwood's got the design already done and right away.
Mhm.
So it's sitting there, it's primed.
Yeah.
And so if we can get this one primed and keep it moving, it'd be great.
Yeah.
How far is Taos's boundary for their?
It's inside this black part.
Taos actually
It's
impacts
impacts.
one of the 4 property owners, and 2 others are in the city limits of Jefferson City.
Okay.
So of the 4 quadrants. So
I
it's-
know Taos has been trying to get the Dollar
So you
General,
see-
so,
This little black line there, just follow that and then
Oh,
go straight
okay.
up to there. And
okay,
yeah, so this would be in city of Taos, county, Jefferson City.
Okay.
This is all that's
Okay.
north of it. So there's a lot of people, a lot of players involved with this one.
yeah, that's good.
Yeah.
Okay,
Okay, so moving next to the Rail Spur Multimodal Transload Facility. Ben, we've presented many times on this, and the project's under construction right now. And in the state budget, there was a $2 million earmark towards the project we were short on funds, as we talked about. We were able to secure that. Now, it hasn't been signed by the governor yet, but assuming that he does, that actually gives us more money than we need for the project. However, the way we designed the project is it was somewhat limited on capacity of the transload facility based on how many cars we could get into the siding coming from Union Pacific. And so with this extra funds, we can actually build out the full siding, which would be, I showed those sheets, I gave you those sheets. We would be able to build out the full siding to allow for the maximum bringing in and hauling out of cars by Union Pacific. And so with that, the transload facility, which is further on the west end of the project, could realize its full potential. So right now where we stand, assume when the governor signs the budget, assuming this is still in, we will proceed with a supplemental agreement with CMPS to do some redesign work, and there's also some construction phase services of the project that we need to add to that. And this would redesign this. We began the process with Union Pacific, reviewing the plans. They actually would prefer this. It just gives them more ability to drop, they call it drop and pull. The less time they spend on our tracks, the better. So they just want to drop stuff and leave, or drop stuff and then pick up stuff and leave. So this is the greatest thing we could possibly do out here. Those sheets that I've showed you, that would be the extent of what we would add to the project with this funding that we've gotten through the state. And it's much needed to make sure that this transload facility can realize its full potential as far as capacity of what we can bring in and bring out. And that's really all I got on that. Like I said, the contractor is working on it right now. They're actually blasting rock on part of the project location. We do have the deadline coming with MoDOT, the FRE grant, to have invoices turned in for reimbursement for the $880,000 that we got from them. It's going to be close, but we will get that. The deadline to submit is June 15th. So we're working hard to make sure that's realized. The EDA grant doesn't have near that tight of a timeline, and so we won't have any issue getting the full amount of that. And on the agenda later is an amendment to that agreement. So, is there any questions about the Rail Spur project?
No, I think it's a great project, so.
I was just kind of over the numbers again, Eric, and I think the total project's right around 5.5 million, right?
Right now, it's bid at, awarded at 4.3 million. It was estimated in the fives. With this extra work, it's gonna put us over 5. And we're getting a $5 million project for a county and city investment of $800,000.
Okay, that's what I was gonna say. We started at 800,000 and we're still at 800,000 investment in it. And then that doesn't even include the property that was conveyed to us for the multimodal. So that was another missing piece that we had talked about earlier.
Right.
So there was a lot of moving pieces of this too. This is, I don't know what other private public partnerships we have had on a project like this, but it's pretty neat to see it happen and see it happen at this pace. So
Yeah, I'd say a lot of different entities involved and all pulled together by the JC Regional Economic Partnership really made all this happen. So it's a good project.
I think all the partners have been just very important to keeping it moving and at the pace it has.
Yeah.
It's just to see something like this come to fruition this quick is unbelievable. I mean, for city or county. So,
It did happen very quick, and
Yeah.
you had to make decisions quick. And
Cool.
we had to get the right information to you all to make the decisions. I will add that we're beginning the discussion with the operator and hopefully have an agreement on that within the next month or two. And that's a partnership of Watco and Capital that we selected for the operator. So we're kind of kicking off that meeting actually this afternoon. So that's all I have on the Rail Spur project.
thanks.
Yeah,
Great. We got everything down before the Indiana bats came.
we
so-
got all that done. Yeah,
Yeah.
everything's moving along.
Yeah.
And really the only last thing on this is just to talk about the agreement with the city cooperative project agreement. I mentioned those dates. It will go to the city council on the 20th. In this agreement will be all three projects that we're appropriating money towards. So Wildwood, the amount would be 1.5 million from each party. Monroe Street would be 400,000 each, and the rail spur would be 400,000 each. The rail spur, it's definitely capped at 400,000. David, correct me if I'm wrong, but Monroe Street, since you don't have your final design done, there may be a supplemental to this if it comes in a little bit over.
Talk about
But
that.
right now, it's estimated at 800,000 total. So we don't need to make any decision on any of this today, but I just want to give you an update. A lot of things happening, kind of all coming together at once. Working with the city and the Public Works and Planning Committee and then our Road and Bridge Advisory Board, all doing different parts to make all this come together, so.
Now, David, I know we've had a lot of people talking about extending Monroe
Uh-huh.
over to Stadium.
Yes.
So this is just 50 to Dunklin, and then at some future date, you'll,
Right, there's been, yes, there's been quite a bit of discussion
Yes,
at
there
Public Works and Planning about what that should look like. And we've presented a number of different options to them. In terms of, how do you make that one-way section two-way? I mean, which way do you try to push the road? What properties are we going to be affecting? And so I think there's still some discussion as to what that should look like, but I think everyone on our end was certainly behind the idea of getting this piece through the rock cut area fixed. And so, that sort of led us to kind of break this into two pieces. To get this one done, everyone was behind this piece. And then as we sort of get into the construction of that, we'll sort of, begin to pay a little bit more attention to the next section and try to sort out what's going to happen there. So I don't think any decision has been made just yet, but certainly those conversations will be ongoing.
okay.
All right. Thank you all, and thanks, David, for helping out.
Thanks,
all.
David.
Thank you.
Something else, yeah.
I think you're still up, Eric, aren't you?
Am I right?
I think you get to go next.
Yeah, 'cause we don't have any commission comments.
Don't run off too far.
Bids and contracts, approval and signing of agreements for professional engineering services, stormwater runoff control evaluation, ARPA projects.
Okay, let me get situated here. So we have, we've been working on stormwater, I would call it runoff control out on the west side of town, kind of the west, all from northwest to southwest part of the county that basically these areas that drain into or drain around the city. So it's been an ongoing issue for us to maintain and address stormwater issues out there. So we made a presentation to the county commission for utilizing ARPA funds, which you all agreed to. We began the process of selecting consultants to do the projects, and we selected two, Bar Engineering in Bartlett and West. Ed Galbraith with Bar Engineering is here today, which I think y'all met him last week, just to acknowledge that he's here. And he's more than welcome to chime in on anything, but if I miss something, you can let me know. So, but anyway, I appreciate Ed being here. So we selected Bar Engineering and Bartlett and West to do these two projects. We split them out. We actually had three watershed areas identified, split them into Bar Engineering doing the Natchez Trace, we're calling it, in the Apache Flats watershed. And then Bartlett and West is doing the Westview Heights watershed. Through that process, we actually determined that we wanted to add a little bit to the area that Bar is looking at, and so we're really calling it the Bender Lake watershed, and so we're adding a little bit of area west of there, shown on that drawing that I gave you. And that, what basically that does is it allows them to roll in the Bender Lake area, because that does have some impact just immediately downstream to the Natchez Trace area. So it just made sense to roll all that into that whole study. So this is going to be a phase one project for both. The first thing we have to do is the hydrologic and hydraulic modeling to analyze existing watershed, and through that identify conceptual improvement options to do the stormwater runoff control. That'll include preliminary cost estimate or opinions and for the possible improvement areas. So like I said, that's a phase one. When we get through that process, and identify areas where we think we can make some significant improvement and we know about what it's gonna cost, then we can begin phase two, and that's the more detailed design of the project locations. It'll include right-of-way plans for acquiring easement to right-of-way or property as needed. It'll include construction documents, final plans, bidding out projects, but we really need to get through phase two before we can begin the serious design get through phase one before we can begin the more detailed design on phase two. So these two contracts or agreements for professional engineering services are for phase one, and we'll do the bar engineering first, and that one is project 2023-201-0, and the amount, not to exceed amount is $160,000. And I would recommend approval of that. And again, these are ARPA funded projects, so I don't know if that impacts or if there's any other things we need to do in relation to them. It's just a standard engineering agreement, so.
Just like pass it by them, but I'm sure it's fine. Plus, it will come out of the ARPA money for the TOs.
Let's see if I can get all the, I don't know if we have all those numbers in here. So if you give it to me, I'd read it back.
Sure.
I'll make a motion to sign the agreement for professional engineering services on the stormwater runoff control evaluation, Binder Lake, Apache Flats, and Natchez Trace watersheds, Phase 1. This is project number 2023-201-0.
Second.
All in favor?
Aye.
Aye.
Okay, the next is with Bartlett West. Same process of what they're doing with the project. And this one would be the Westview Heights Watershed Phase 1, project number 2023-202-0. And in the amount, the not to exceed amount of $114,062.
A motion to approve the stormwater runoff control evaluation Westview Heights Watershed Phase 1, project number 2023-202-0 with Bartlett and West, not to exceed
Towards the bottom of page 2.
114,062.
Mhm.
Second.
All in favor?
Aye.
Aye.
Could I just jump back to that first one and say that it includes the name of the firm and the amount of 160? Is that okay?
Yeah.
All right.
And does the company reviewing the ARPA stuff, do they need to look at this first, or you think it's okay?
We'll run it by them, but
Okay.
we've had enough experience with them that we know how they treat us and we treat them, that I don't think it's going to be an issue at all.
Okay, we're gonna do kickoff meetings with them, maybe even start next week, so.
Okay.
Just to keep things moving. I know there's a date of the end of '24 to have projects encumbered, and so things need to start pulling together pretty quick to make all that happen, and so,
Right.
yeah, we need to keep moving on it. Okay. Yeah, so you need company information and all that. Oh, okay. Get you all that. Okay,
Okay,
yep.
Thank you.
all righty. Unfinished business. Oh, no, we got approval and signing of the contract with Renewal Biomedical for preventive maintenance of EMS medical equipment.
Morning.
Good morning.
This is a quote contract with Renew Biomedical to perform the preventative maintenance on our ventilators, 11 of them, and our IV infusion pumps, 32 of them. This equipment requires annual maintenance to make sure that they're working correctly and in proper order, and then any software updates. So these folks will be coming to us, performing that on site. This is in my equipment service contract budget for this year. However, it is a little over budget. That is because we added in the PM of the IV pumps, which we've owned for several years prior to my arrival, but have not had any preventative maintenance. So we want to go ahead and get that taken care of. So total quote is $11,230. I believe we had like 9,500 budgeted for it, but there were other savings in that account that will cover the cost.
So keep it in that account, I don't have to do a transfer or anything, it'll still be all right.
Nope, yep, so there's savings in that account. The only other thing is that Jill did catch that there were some confidentiality clauses in here. We did reach out to the company, and they agreed to waive those just due to our compliance with open records law. So if that's crossed out here, Sam will just need to initial that when he signs.
Okay, good? All right. Make a motion to approve and sign the contract with Renew Biomedical for preventive maintenance of EMS medical equipment.
Second.
All in favor?
Aye.
Aye.
Thank you.
Okay. Unfinished business, Cole County Multimodal Transload Facilities, EDA Amendment Number 1.
Sound like someone was taped.
You tried.
I'm sorry. Are you all right?
I did not mean for that to happen.
Okay, with the U.S. Department of Commerce Economic Development Administration, EDA, grant that we got for the transload facility, we have to do an amendment to the financial assistance award. The original, when we submitted the grant application, the estimated cost at that time, it was very preliminary, was $3.1 million. And with the awarded amount, we have to do a change to this award through EDA to add to the recipient share of the cost. So nothing's changing on the amount we're getting through EDA, we just have to change what approved costs through the project and added to, or the additional that we have to come up with. So we just need approval of this to move forward with EDA.
The 3.1 becomes,
It actually becomes $4,093,265.33. The award amount for the project is 4.3 plus, but there's some parts to the project that EDA doesn't pay for, doesn't include. It was
Right.
additional things. So that's what actually is going to be in the document. But all we're doing is changing the amount that we have to contribute to the project above what was originally in the original application.
I'll make a motion to sign EDA Amendment Number 1 for the Cole County Multimodal Transload Facility.
Second.
Yep. All in favor?
Aye.
Aye. Okay. We're down to new business. Yeah. Accounts payable review.
Yeah, I would ask for approval of accounts payable pending review.
Okay,
Oh.
I'll make a motion to approve accounts payable upon review.
I second. All in favor?
Aye.
Aye.
David, remind me to go through those.
Yeah. And I'm not sure you're in, we're just
Oh.
having a small group this time, it's just public
Right,
works.
it's just
so
like a few checks for
it's
Make
just
it a yeah.
sheriff's office, yeah.
Okay. Aye. Aye.
Okay, all right.
Okay. Zimmer Recruitment Plan, 1-month extension for social media.
You guys already know you approved our contract with Zimmer on recruitment. The contract comes to fruition probably in, I think, in 2 weeks. This is going to extend it another month with our new pay raises in place. It's $5,700 that we take out of contingency. Daniel and I looked at it, and we both agree this is the best way to move forward. Right, Daniel? Sure. There you go. So,
Brian got a replacement, huh?
Brian's here too, so.
Yeah, Brian's here too.
Sheriff, what can you say about the first period of Zimmer in terms of contacts,
We got a lot of.
results?
There was a lot of hits, there was a lot of likes. The message is getting out there pretty good, because they came in and gave us a report. As far as people actually saying that this is where they heard about the job, the individuals that are coming in are saying they heard about it on a job, and that might not necessarily be the reason why they came in. But they did say they heard it on Facebook, on Twitter, and whatever other food that they put that out on, I have no idea.
Yeah, I'm okay
Okay.
with it.
Yeah, I had asked him the same question, so.
I make a motion to sign the recruitment plans social extension for 1 month at a 2 weeks, I'm sorry, for 1 month, and the investment is $5,700.
Second.
All in favor?
Aye.
Aye. Okay, approval of emergency plan reference guide.
Okay, well, you guys remember, we've been working on this for quite some time. This is what the courts looks like as far as their plan that they had, and they designed it just for the courthouse. The safety committee got together and wanted that updated. So we've come up with an updated version, and we're ready to go to print with it now. It does follow all of our current policies that we have. I know there's a debate just about one of the policies, but it does follow the current policies that we have now.
No, it doesn't. Our post-accident testing policy is limited to 4 situations. And that emergency manual says that after any accident, they have to be drug tested.
And if you look in the workers' comp part of that manual, it does say there, any accident.
No, the workers' comp doesn't say you have to be drug tested.
So, okay. If you have an accident, I mean, define accident. If you have a paper cut, or if you go to the hospital or require medical attention, I mean, what, because I'm looking at it from our end, and I'm wanting to protect our backsides.
Okay,
And
so our policy manual,
Whether they are showing that they have some kind of reasonable suspicion or whatever, I think they should still be tested if they're gonna be having a work comp claim. That's just, I saw your emails going back and forth, I saw both sides
well,
of
this
the
is
argument.
about, this is about more
About
than workers'
rights
comp.
and the, you know, the Fourth
Post-accident
Amendment rights.
testing, our manual says required for all employees in the following situations. After a vehicular accident has occurred, regardless of fault or severity of damages and regardless of whether or not another vehicle involved in the accident. 2, when a traffic citation is issued to a county employee after an accident. 3, when an injury to a person requires transport to a medical treatment facility, or when disabling damage to one or more vehicles requires towing from the accident site. So, in order to drug test somebody, part of the issue here as the government, when you drug test, whether it's your employees or in the case of OSHA, requiring drug testing for employees of certain businesses that they regulate, it is a Fourth Amendment search under the U.S. Constitution, which prohibits unreasonable searches and seizures by the government. So, if you're going to drug test someone, under the U.S. Constitution, it has to be a reasonable search. Now, the U.S. Supreme Court has made rulings as to what is a reasonable search. Okay, obviously a warrant, but there are also warrant exceptions. They carved out exceptions for transportation-related fields because the expectation of privacy is outweighed by the safety need. Same for other safety-sensitive positions. And then if you're also going to drug test someone, and they're not in those areas, there's reasonable suspicion testing. In other words, you have reason to suspect the person may be impaired. But just drug testing across the board for anything without some sort of nexus between the cause of the accident, you know, a plausible explanation would be impairment caused this accident. If the ceiling tile fell on top of my head and I had to be taken to the hospital, there's no plausible nexus there.
So
And-
that's what I was coming from, is where would that line be drawn? Is there a line that is drawn, or is it gonna be subjective? Because you can slip and fall on ice and be like, well, it was ice, it was icy conditions, it wouldn't seem like it was, there's your nexus. Well, maybe you were still jacked up on something, and I wanna
And-
get you tested, because, you know, we've got employer rights too, we gotta try to protect ourselves.
Sure,
So
sure,
that-
Jeff.
But,
And I
but a
think-
ceiling tile, I hadn't really thought about if something falls on you. You know.
Yeah, right. And I think that's a case-by-case argument. And if you can come up with a plausible explanation, you have your defense. As I said in the email, if someone feels that he or she has had their Fourth Amendment rights violated, in other words, made to take a drug test and it's not a reasonable search, there was no reason to, in that particular incident, what they can do then is file a federal civil rights lawsuit. Now, in that case, the county's not going to be the defendant unless we do happen to have something in our policy manual that's unconstitutional. That lawsuit is going to be against individuals that this person believes participated in the decision to violate that person's Fourth Amendment rights. And you're going to be named in your official capacity, but also too, depending on the facts, if there's some sort of other motivation or there's some serious recklessness on the part of the decision-making, then you can be named in your personal capacity. And that kind of judgment is not going to be covered by our insurance company. So I guess my point is, I think the emergency manual needs to follow our policy manual directions for post-accident testing.
Jill, you and I have discussed this too, and I like the language that's there in our policy manual. And your example was the ceiling tile. My example is that 3 employees step onto the elevator, and the elevator malfunctions and they drop. And Eric comes and picks all 3 of them up. That's an accident on the job. These people don't need to be drug tested. They didn't do anything to make the elevator drop. And if we demanded that they all 3 be drug tested, I think we're crossing a line.
We're violating their civil rights.
Yes, that's the line.
You're exposing.
But, so what, the policy manual we have here is pretty good.
I have no problem with the post-accident testing language.
Okay, but that conflicts with something over here?
Well, there, it's just across the board, any accident, it says that the elected official or department head needs to get them drug tested within an hour.
I think, speaking, and other directors in the room can speak up, I think I would like some further definition on what constitutes an accident. So we are happy to comply with the policy as written, but the term accident, currently, it means any sort of injury that is, right, but I don't think that in the current form, unless I'm reading it correctly.
You're
it's-
talking about the emergency manual.
I don't think in the employee, in the county policy handbook, it does not specify a vehicle accident. It states anytime an accident has occurred. So if we are changing this to a vehicular accident, I think that provides,
That's in there. You looked before, after a vehicular accident has occurred.
I know, but in the current county policy,
This is
the
the
word.
current county policy. You're talking about the emergency manual, right? That's what we're talking about here.
I might have my pieces confused, but I would just like further guidance on when somebody needs to be tested. I would like it to be black and white. In this scenario, this is when they go get tested. In this scenario, you have to have reasonable suspicion, because we just want to comply with what's right.
And I'll just throw in, if one of my people are assaulted, then we don't need to get a blood test. If they're in training and someone gets injured, which isn't out of the ordinary, we don't need to get a blood test for that, because I think you're right. I don't remember who brought it up. I heard the word causality. I think that's what we really have to get this down to, what the causality is. If there is reasonable suspicion that there was some kind of drugs or alcohol involved in somehow, then maybe, yes, I can see why you would on a training issue. But I just think we really need to look at the causality rather than carte blanche. If it's an accident, you gotta get.
So, from my perspective, my question got brought up. We had an incident earlier this winter where one of our employees was exposed to a bodily fluid and had to go receive workers' comp testing. Well, that piece required him to go get a drug test. So, is it their fault that they got sprayed with these bodily fluids in the performance of their duties, and do they then have to go get a drug test? Is that reasonable? I don't know,
No,
but I think
it's not.
that's the situation that we want to try and address here.
Absolutely.
And that's under the workers' comp part.
Well, then, if it is, it's unconstitutional, because there is no reason to believe this person, your employee, was impaired, correct?
Correct.
So it's an illegal search. As I said in my email, OSHA's regulations require some sort of plausible connection between the injury and impairment.
Between the accident and the impairment.
Right. The accident or the injury that was caused.
Right.
And again, we don't follow OSHA regulations.
Well, but here's what I said. We're not regulated by OSHA, but I gotta tell you, if you get sued in federal court, a federal judge is going to look at the OSHA regs as guidance for what is or is not a reasonable search. Because OSHA, as a government agency, has to follow the Constitution. And they are not going to put into their regs requirements that are going to be found to be an unconstitutional search, an unreasonable search. I'm here to protect the county. I can't tell you, make you do what you're gonna do, but just letting you know what could happen.
So what's the language that is objective or is problematic? What language in there?
And emergency thing?
Yes.
Here's the page.
Because we don't have a problem with policy
No,
over there.
I'm gonna ask Sheila, what's the policy book itself?
here we go. Or him or life-threatening injury, immediately get drug tested as soon as possible.
Yeah, okay.
But there's no,
So in my example of the 3 employees who stepped on the elevator crashed, they all have a broken leg as a result of dropping 1 or 2 floors. Does this, if we adopt it, say all 3 of these people have to be drug tested? And our attorney says that's an intrusion and a violation of the Fourth Amendment. They don't, and I.
it's not a reasonable search.
It's not reasonable to drug test these people when all they did was step on the elevator and hit the button and,
I would absolutely agree. So what is work comp saying? Is work comp saying in order to cover this, we're gonna have to have them tested?
The law does not, Jeff.
I understand that. I'm on a total different binge here with the work comp, because if
But
work
what
comp
I'm-
can't be coming in here and telling us that we have to break the law to
Right.
get them covered, so.
What I'm saying is the Missouri Workers' Comp law says that if you are under the influence, your benefits can be reduced, but it does not say that you have to test people.
well,
Right.
I think there might be a difference between your work comp. Your work comp is the carrier, your work comp is the statute.
Yeah, I'm talking about our
They
carrier,
have
what
to
they're
follow
telling us.
Missouri. They have to
Oh, well, I know they do.
So
but-
then
But we're all back to the Fourth Amendment, unreasonable search and seizure.
Yeah, so how can
Missouri
they,
law
how can
can't
they
require
require?
you to be drug tested if it would violate your constitutional rights.
Right?
So how can we tell them when they tell us that we have to have them drug tested after the elevator fell? Tell them go pound sand, they can go after them and, you know,
Well, we had that issue already with the one employee who, in line of duty, was
Bitten by a
bitten by a
dog.
dog. And then we said, well, you've got to go get a drug test. I mean, she was, you know, she
Well,
was
there's no
doing her
evidence of
job.
impairment.
So to me, that made no sense.
Sure, and I tell you what, if she had been made to do that and chose to file a case in federal court, wouldn't be good for us.
No, it's, so I don't know what we've got to do, how, but I think before we approve this, I think we need, we need to sit down and just, because, you know.
I think Debbie's argument was that the work comp insurance company was the one telling us that we need to do this, right?
And plus, I feel like it's in the
Not,
manual. that-
not state work comp, but,
The carrier.
so,
So-
yes, so
And
that's
our
why I think
premiums
we
are-
need to really clarify what's going on.
I want to see in writing from them that they are requiring that everyone, if I get carpal tunnel and need to, and it's attributed to my, using my mouse and I'm on workers' comp, I want them to say in writing that you have to be drug tested. Because, let me tell you, that's not going to fly with the federal court.
We're just trying to follow the policy that we haven't.
Well,
And so, the policy needs to be rewritten,
Yep.
and it needs to be rewritten by council so that we know that it's compliant, not just a blip given to me. We need to have it worded correctly. Work comp makes strong suggestions that we have post-accident testing done, and our premiums are based on it. So when we take that requirement out, our premiums are going to increase, and we'll just deal with that.
Well, we will, I guess,
don't see any
but I
place
don't.
in our policy manual, occupational leave workers' comp, where it says you have to be drug
It
tested.
does not.
So
So what change?
MEM
needs to
is
be
our
made?
carrier.
Whatever you're wanting made to.
Currently, right?
You need to make changes.
Okay, I want MEM to tell our attorney, I want the MEM's
Regardless
attorney.
of the causality, that everyone has to be,
They will not do so. It is a strong recommendation that everyone is drug tested. They are not demanding that we break law. They are not telling us that every employee has to be drug tested. Our premiums are based on the fact that we have a policy in place and that we follow it. All we have to do is tell them that we are gonna follow the drug policy in certain circumstances. They will then base our renewal premiums on the fact that we're not testing the entire population like we have been, but we're following law and the recommendations of our council. No big deal.
All right, I just think there's a disconnect between what we say MEM, and I don't mean to disparage MEM at all, but an insurance company strongly encouraging its customer to approach, if not jump over the fence and violate the Fourth Amendment.
well, and here's part of this thing too. Private businesses can drug test anybody anytime they want to, because the Bill of Rights does not apply to private employers. It applies to government employers.
Well, and then the CDL drivers, they,
That's a different deal. The Supreme Court has carved out exceptions for transportation workers. These are, you've got the law, you've got the Constitution, but it's interpreted through the courts.
But
So
even
you-
if there was somebody driving for us and they get T-boned, which is obviously not their fault, I'm not sitting there saying they have to go get drug tested either. I mean, that's,
And that's your call,
I'm
Jeff.
trying to figure out where the black and white is. But that says we have to.
Easy enough to change that.
I think anything in the workers' comp, I would recommend that it mirror the OSHA regulations, because those have been vetted and found to be constitutional, and those are their requirements for drug testing, and which require some sort of plausible connection, arguably plausible connection between the accident and impairment.
And who's gonna determine on the side of these accidents which one counts and which one doesn't?
Put it this way, it's better to err on the side of not testing than violating someone's rights.
But I can always have suspicion on anything if I want to.
Well, you have to have objective
So were you
reasons.
drunk when you
for
got
it.
on that elevator? You know, I saw you stumbling when you got on the elevator, but did you make the elevator fall by any means? It's
So you're gonna test one of the three with the broken leg, but the other two broken legs?
not- I don't know.
Well,
I'm just playing both.
It's a facts and circumstances thing, and I don't know.
I can have suspicion pretty much in any instance. You know,
Okay, well, I would suggest we go back and let Neil review the policy. It says the workers' comp part of that policy and the drug policy is in line with what we're doing. I don't
Can
really
we-
know on workers'
I mean,
comp what I'm gonna be doing.
you're not gonna write it up in black and white, but I think, can it say that we can or may be tested after any accident to be determined?
Well, Jeff, you can say whatever you want, but it doesn't make it constitutional. In that case, if you've got a
No, but we're
policy,
saying that it can be to protect our asses, and then they're gonna be protected by the constitutional amendment. And if we look at it at that time and say, well, the elevator broke down, no, we don't need to have you tested. You got bit by a dog, no, we
Well-
want to have you tested.
we have post-accident testing. We have conditions that are already in the policy manual, and I think they're reasonable and constitutional about when a person.
So that one needs to be in here, is what you're saying?
Yes. What's in our current personnel policy
Okay.
manual, I have no problem with. Workers' comp has nothing to do with,
There's testing involved.
I know that, Debbie, but I'm just saying, this is an emergency manual, it's not a workers' comp manual.
No, but I wanted to reflect
I
that.
believe in the manual, there is a subsection that talks about workers' comp, which has.
There is.
Which has contradictory language to what you have here. So there's.
I don't, no, I don't think so, Eric, this is just in general.
I'd like, we sit down and review it afterwards, because we looked at it yesterday, and again, the issue here is that it's confusing, and we as department directors in the moment have to evaluate the situation. So I would like to have some sort of guidance on which way to go, so that when these, it's fine during the day when we can reach people, but we know these things happen at 3 o'clock in the morning, and if I need to send somebody for drug testing, I don't want to wake everybody up.
Eric,
trying to.
drug testing is not addressed in the workers' comp policy. It just gives the general way workers' comp works, the post-accident testing.
She's right.
So why don't we have a sit-down with, at a maximum, one commissioner and directors, attorney, HR, so on, and hash this out until we have satisfactory language for all the players.
Well, and I'm gonna research it too. I've got lots of articles and I've got court opinions, and I think the way to go would be to look at the OSHA regulations and see what their language is as far as, that kind of testing, post-accident testing, because that's been, if that were unconstitutional, it wouldn't be there.
I'm curious as to whether or not carriers, the insurance companies, have a different view of a governmental customer and a private employer customer.
Very possibly.
And
Well,
that's-
there is a difference.
I understand, and that's why I want to know if they say, wait a minute, we gave you the private company page, and we wanted to give you the government.
Yeah, that I don't know, but one would hope they learned in high school civics that the Bill of Rights applies to government employers.
So when one of John's deputies hits a deer, is he drug tested after,
As it stands now, yes.
as it stands now?
As, under the post-accident testing.
Okay.
And you could plausibly say, I think you can protect yourself by saying, okay, this is a vehicle accident. Chances are, the deer jumped out, but we don't know. Maybe he could have been impaired. So, I mean, that's not as,
Okay, well, I
So
just,
now we can, and I can't.
Well, there is,
I need black and
there,
white.
no, you're not gonna get a black and white, not in every case.
Okay, then I'm not making any call.
Well, I'm
Well,
sorry,
that's what
but there
we're
is no
figuring out.
black and white, hard, absolute, we can tell you
it's all,
everyone.
it's all fact dependent.
It's facts and
And
circumstances.
I don't
Yes.
get the facts till 2 or 3 days later. So that's just what I'm saying. Okay.
Okay, well, I think we,
Plain. I
yeah.
don't get
Well-
the facts till potentially 2 days later.
I like here, let's create a committee and sit,
I would like to have black and white too, but I'm not hearing that it's gonna happen, because I think there's gonna be too many things in there that are subjective, just like the deputy, or anybody hitting a deer on either taking mileage or driving a county vehicle,
And this is how the law works. You go to court and you have either the judge or jury as the fact finder. And it's fact-based. It's not black and white, always. And that's, it's just fact-dependent.
And besides that one, we haven't had anybody in the last 30 years that have refused to test. So.
yeah.
So it's not like it's a big issue with our employees.
it's not a
They know
big
they
issue,
work
but it's
in-
trying to get it written up in there
Right,
to where
right.
we don't have things contradicting each other, so.
Right.
Of course, that doesn't mean in 30 years you haven't been violating people's Fourth Amendment rights either.
We wouldn't do that.
Certainly not when
That's what I
council
would
looks at that
probably
handbook every
publicize
year.
right now.
And just be aware, the people who are involved in that decision to make someone drug test who constitutionally should not be, are gonna be named in that lawsuit. It's not gonna be limited to the commissioners.
Well, and I think we
And that's
need,
why then if you're gonna make me make those calls, if you're
No
gonna
one's
make me make
making-
those calls, then no testing.
we need to update the incident reports
Yeah.
for EMS, sheriff, internal, all of those, to where there's a declaration in there. There is a suspicion this person is under the influence or impaired, or there is not. Let the directors and them decide whether or not there's a drug test. Then that way it takes it off the commissioners, it takes it off of Debbie and I. It makes you responsible, all the other directors responsible for whether or not someone was drug tested.
And Sheila, the big thing is the evidence of suspicion of an impairment, because that is going to be your defense.
Observation can be the evidence,
I'm
as
not-
is suspicion as well.
That's not,
Don't
I'm
jump
not,
at me, Jill, because we're gonna get a,
okay.
Okay.
I'm not disagreeing with that.
okay,
Observation is evidence.
that's right.
And
Yeah,
I'm just saying there needs to be evidence.
okay,
And that's why I
let's,
just said we'll alter the form.
let's have a committee get together and let's hash this out.
For the record, EMS hits deers too. You brought me up 3 times, put that out in the universe. I'm just saying,
And they
EMS
gotta
hits deers
test it
too.
Well, but I signed, these titles for vehicles are all yours. They're not,
And we're not even getting in about ambulances coming off of trucks and hitting other cars or anything, right? We're not getting into that, are we, Eric? Daniel's the one that brought it up, I'm just saying.
just don't hit any more deer.
What'd you say about a goose, Daniel?
Okay.
I wanted to jump
We're
in
gonna,
on
we're
that
gonna
one.
table, approving the emergency plan reference guide. And we will have a meeting and hash all this out and then bring it back to us. Okay?
All right.
Okay. Do we have anything else?
Yes,
No.
I know that it
We're,
surprises you. but
you
one
said
of
we were
our-
pulling the LEPC
Right. this
train
is-
expenditure, so I wasn't gonna,
This is the emergency purchase for the West Sally Port Door.
okay, yes.
It went, surprises you, I know that one broke, but it did, and maintenance came in and got it down, it's secured. However, we can't use it right now. I gotta have that, it impedes my operation, I gotta have it fixed. It's gonna be about $3,200, $33,232. I would ask that we go ahead and move forward with this emergency purchase. Jill has looked at this contract and it's okay. Daniel said it's a good idea also. And I did check and we are under the 3-month.
Okay.
So,
And none of your deputies hit the door?
no, nobody hit it this time. Ambulance didn't get caught in it.
Okay.
Wasn't FedEx?
FedEx
No
truck.
FedEx trucks.
That
Nope.
was- yeah, that was fun.
You good with that, Daniel?
Yeah.
Make a motion to spend $3,232.00 to repair the Sallyport west side door due to an emergency occurring yesterday?
Actually, it was on Saturday.
Due to this Saturday emergency or accident. Was there anyone drug tested as a result of this accident?
I didn't even
I was
know
gonna,
that.
I was gonna bring it up.
I didn't ever.
Never mind.
I was
I've
gonna
been
bring it
second.
up.
That's not part of the, that's
Yeah.
not part of the,
Daniel actually brought this up.
We have a motion and a
He was
second.
really angry about it. I calmed him down, so don't bring it back up in front of
All
him.
in favor?
It's okay.
aye.
Aye. Daniel, are you okay?
You just need to calm down, brother. You're all right.
I did.
Harry
He
did.
did, he seconded.
So we're done with regular business then. I just want to bring up
Yes.
the cornhole
Yes, we need teams.
fundraiser tournament is June 16th. We're trying to get as many teams there. Doesn't matter your skill level, good, bad, ugly. Public Works doesn't have a team in it yet, but I think Eric said he'd get about 4 teams in there, right? No, absolutely. It doesn't take any skill to come out there and have fun for a fundraiser. Sam will be there. He's not even gonna throw.
No,
So you can come out to it, there's gonna be a bunch of prizes, there's gonna be, some giveaways and different things, so come out there. and do
lots
some
of good
food.
giveaways.
So, I'm trying to make some money for this thing. Yeah, you don't have to be good, I prefer that then, I wanna throw against them. Make me look better, so. But yeah, just remind everybody, we're trying to load this thing up, and it is a good time. I think that's all I had.
Sheriff's barbecue.
Yeah, Sheriff's Barbecue tonight,
Tonight,
4
4 to 7.
o'clock to 7.
Yep.
And there is
You can buy
carry out,
tickets at the door.
right?
You can buy tickets at the door, there's carry out, you can buy
Okay.
tickets for carry out, pork steaks, rotisserie chicken, and bratwurst.
Perfect.
We good?
We're good.
You good?
I'll make a motion that we go into closed session pursuant to section 610.021 of the revised statutes of Missouri. The commission will go into closed session to discuss the following: real estate under 610.021 subsection 2, existing of proposed security systems under section 610.021 subsection 19.
Second.
That's it.
Roll call?
Sam,
Yes.
Harry,
Aye. Yes.
Jeff.
Yes.
Good job, bud. Appreciate you getting that through for me.
We'll put a tie on him, he can sit in here every week. You gotta wear a tie.